Hello viewers and my students who are watching this video. I am here teaches you the Pocso Act 2012. Before starting of this new chapter as well as sections, I want to remind you that in last videos you have seen the offences regarding Pocso Act and their punishments. In this chapter, means chapter 5 includes the procedure and recording of the offences by which the punishment and prosecution may be go ahead. Now let us try or let us start to inform you, start to see that what are sections which are included in chapter 5. So from section 19 to section 23 have been inserted in chapter 5 of Pocso Act. It is very vital and very important chapter. Also, it has some glimpse over the examination of judiciary, in which some important questions are also asked from this chapter, that what are the procedure by which cases of Pocso Act or Pocso offence may be recorded, and to whom the cases may be reported, all these things. But after this, it is also important to note that not only the person but media and responsible person like hospital, management, institution, hospital, and so many institutions are responsible for the giving the information to the police, local police or a special juvenile police unit, and these police are responsible to enter the information or complaint lodged by either child or the person who are making this. And this is already incorporated in the section 19. This is all about I am telling you. After this section, there is also a description in another section of the media and photography places and studio who are also have responsible to inform the police in this regard. Not only this, some years ago in 2017, Mr. Swami, leader of BJP, has made the statement against this chapter, that judges must be, or not only this section must be abolished by the government, that in which judges are also included to inform the police if there is a apprehension of committing the offence or has been committed the offence, and it is in the knowledge of the judge that he knows the commission of the act, commission of the offence, so he has a responsibility to lodge such or to make such information to the police or a special juvenile police unit, and it means not only responsible person, not only person, but everyone has his responsibility to make the information to the police so that case may be initiated from the proper channel and the accused must be punished in a short time. Now let us see one by one so that you may be clarified further. Let us see what section 19 says. Section 19, chapter 5th. Section 19. What it says? Its headline is reporting offences. This is your headline. Chapter says procedure for reporting cases. This is headline of chapter 5. But what chapter 5 includes? It is reporting offences. Before that, if we remember CRPC 1973, it also provides some provisions, some ways, some methods by which you can make complaint or lodge complaint against offences against the person to person. Now, in spite of that, notwithstanding anything contained in the CRPC, any person, including child, has a apprehension or there is apprehension of committing an offence relating to Pocso or has been committed the offence of Pocso Act, then it is his duty to report to whom? It is first section 2, subsection 2 of reporting offences to local police, third special juvenile police unit. Either of them shall record such complaint in the recording book kept by the police with it. Not only this, the police shall shall ascribed entry number and in writing. Now, after this, one thing is very important, that in case of in case of a child where he lodges the complaint to the police and recording might have been not understandable to the child, then the police has to make the arrangement of a translator or expert so that the meaning and language of the written substance must be clear to the child. If he does not able to understand the same, this is the process when a child especially makes a complaint against the offense to the police, means local police or special juvenile police unit. Now, if the child making such complaint is in a position to harassment, in position to unsafe, and he finds himself unsafe, then in such cases or in such case, police have to take care, as well as he has to make the protection to the child at once. Not only this, next thing in this section 19 says that the police has to inform within 24 hours to the Child Welfare Committee. Not only this, also if there is a special juvenile court or a special court for POSCO, then such information must be given to the prescribed authority. Not only this, the session court also will able to be given such information immediately. This is all about your section 19. Now let us see section 20. Section 20, what it says, what it tells? It tells that obligation of media, studio, and photographic facilities to report cases. This is punchline or headline of section 20. In this section, it is only said that the personal, not person, personal means the authority has to make such information if there is a if there is a information of any apprehension of commission of offences or has been committed offences of this act, of this adhiniyam. So he has obligation that such information must be given by him immediately, so that a failure must not be done. If failure is done, in next section we shall see if such failure is committed by personal or ordinary person or employed person there, then they are liable and they shall be punished under this section, and the punishment may be imprisonment of 6 months and fine, and with both also. This is the thing. So it is obligatory. Before that I have said that any person can, in which child is also included. In person, judges are also included, and this has been made earlier clear to you also. Now, section 21, it is very vital. It stands with the punishment for failure of report or record a case. Here it is headline: punishment for failure to report or record a case. in this section, it is said that any failure made by a responsible person, who is responsible person? Actually, a child may be also responsible, but for failure of a child to inform, it is not punishable because he is a child. But a person who is an adult, he knows everything, every pros and cons of the matter. He can lodge a complaint, and so if he fails to comply, he fails to make such information to the police, then he shall be punished, and that punishment may be of 6 months or fine or with both. Now, not only any person from institution, any person from hospital, any person from education institution and company and so many others responsible institution may also have liability to inform the person. And with that, employees or the person working and having there in the company, institution, hospital, club, everywhere, both of them, either management or the responsible person or the employee, both are responsible to make such complaint to the police in this regard. This is very vital. Otherwise, not only employee, but the person who are managing the institution, who are managing the company, who are managing some other institution, and they are also responsible, and they shall be punished in such a way, and which shall be of 6 months of with fine or with both. This is all about your section 21. But in this section also, child has been exempted from the punishment since he is child and not adult. Now, the section 22. Section 22 is also deals with punishment for the false complaint or false information. This is your headline of section 22. This is very vital. What is the meaning of false statement or false complaint? Sometimes in our society, there is a rivalry group. In Hindi it is called हम आपका विरोध करते हैं, आप हमारा विरोध करते हैं, and there is no amicable relation between us. What we see, what we do the wrong thing against the rival group, and similarly a rival group also takes the opportunity to act in a such way that his intention is to make you suffer by making a wrong complaint upon your reputation, upon your goodwill and your prestige. So, intentionally someone makes false statement, false complaint or false information against you, and then if it is found by the court that false allegation has been made by such and such person, by such and such institution, by such and such group, then punishment has been established, punishment has been given in such a way, and that may be for 1 year and fine, and it may be both, with both. This is also a clarify in false complaint. Now it has 3 subsections, 1, 2, 3. In subsection 1, it is said that a person who makes any complaint regarding the offences like section 3, 5, 7, 9. This is very vital sections regarding the punishment as well as the gravity of the section or gravity of the offences, so that the revenge can be taken by the person who is making the complaint. So, if the false statement, complaint or information is found in these sections, so the person making such allegation must be punished immediately. Not only this, subsection 2 says that if a child has made such false complaint or information, he must be exempted so that or because he is child and he may in or may not in good faith. So, by the way, an exemption has been made in the case of child. Now, the third subsection says that if a child, in section 3, if a child makes false complaint or information against a child, knowing to be false information, such child under this act shall be punished for imprisonment of 1 year or fine or with both. This is your section 22. And lastly, section 23. Section 23, headline is very light. Procedure for media. This headline never gives you any clear clarification or object by reading or seeing procedure for media. What is this? So, in this section, media means studio, photography facilities center, some other information center, internet, video, all are included in these sections. They are prohibited, they are forbidden, that they must not be able to, and they not only that, they should take himself away from giving any disclosure in media or print media or video or on internet or any video by which name and address and particular identification of a person who is victim or he is supposed to be victim of the offences under this section, under this act. So, they have been prohibited to do this act. So, this is very important to note down these things, and the punishment for this act is also given if a media or responsible person or any other print media or studio or someone by video making such information in the air, they are also punished by this act, this section, and that is 6 months and fine and with both. Thank you. This is for today.